Hi, my name is Robert Chelle with Chelle Law, and my law firm assists dentists with employment contract issues. Today I'm going to talk about is 2 years too long for a dentist non-compete. So first, if you are either a dental associate or maybe you're a partner, you're still likely going to have some kind of non-compete. And so if you've signed an employment agreement, there's going to be a section in there that's called restrictive covenants. And then the restrictive covenants essentially prohibit you from either doing things during or after the contract ends. So standard restrictive covenants would be like a non-solicitation agreement, a non-compete, non-disparagement, some kind of confidentiality clause. So as far as a non-compete goes, a non-compete will then prohibit the dentist from working within a specific time period, within a certain geographic region from the location that they're practicing in. So let's just give some examples. Let's just say your non-compete is for 1 year and then 15 miles from your primary practice location. For the most part, that would be considered a reasonable non-compete. Now, non-compete laws do vary state to state. It's one of the only things in employment contracts for dentists that kind of varies state to state. There are some states that absolutely prohibit, meaning it's illegal to have a non-compete for a healthcare provider in that state. There's only a handful of those. So the vast majority of states do acknowledge non-competes as long as they are reasonable. So is a 2-year non-compete reasonable? I would say no. Ideally, it would be 1 year and no more than that. However, there are plenty of places that try to push it to 2. In a scenario where they're offering 2 or even beyond, you need to push back and say, I don't want to sign more than a 1-year non-compete. And then 2 other things you need to think about as far as the non-compete. First, the location listed. As you know, big conglomerates are kind of gobbling up these dentist-owned practices. And so you could be in a city where there are 8 locations for your employer. You want to make sure that it specifically says your location or maybe the 2 locations where you spend the majority of your time. You don't want to sign a non-compete that states that it attaches to every single location owned by the employer, even if you never worked in those locations at all. This is especially true for dentistry. Now, if you're in a private practice, dentist owned, they only have 1 location, then it's simple. It's just going to be that location and nowhere else. But if you're in a big city and they own a bunch of locations, you want to make sure it specifically states your location, not all of the locations. And then also, if you're in a specialty, you don't want to get stuck from not being able to do any kind of dentistry. You want it to say specifically what you're doing for that employer. That way, if you can do other things for the period of time, like let's say you just can't move because of kids or family, reasons, and you could have an alternative, for a year. Now that might not be ideal, but you could do that for a year and then come back to your normal specialty. And so you want to make it specifically not like all practice dentistry, but your specific focus as well. Non-competes are just a part of almost any employment contract. I'm not sure why most people think they're just completely unenforceable. I get that a lot. Well, my colleague said that I can sign it, but it can't be enforced anyway. That's just not true. If it's not in one of the states where it's prohibited, it likely will be enforced if it's reasonable. Now, if someone's giving you a 5-year non-compete that knocks you out of an entire state, clearly not going to be enforced. But you may have to litigate or go to arbitration if you're going to fight that, or the employer is as well. This is certainly something you can negotiate. Most employers are going to say to you, well, we just can't, we're unable to change that. Or no, I'm sorry, we can't do that. There's a difference between they don't want to do it and they can't do it. So it would depend upon how much leverage the dentist has Are you coming into a job opportunity that's difficult to recruit to, or maybe in an undesirable location, or maybe not as desirable for the general population? You have more leverage. If you're going into a big city and there's a ton of applicants for a job, and someone else doesn't care at all about the non-compete, well, then you have a decision to make whether it's whether you're willing to accept it or not. If you have non-competes that have like 50 miles from your location, or even will knock out like contiguous counties, that's something I would try to avoid. You really shouldn't have more than 10 to 15 miles from your primary location. Or as I said before, if maybe you split your time, then those two locations. So that's a little primer on non-competes for dentists. If you have any questions, you can call my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. Anyway, hopefully that was helpful. I appreciate you watching the video. Thanks.